So David just spoke about the interdisciplinarity, and that leads directly to my discussion, which will discuss some issues of privacy by design. Okay, privacy by design. Privacy by design is a wonderful idea, but it doesn't quite work, or it might work, and we are here to figure out how it can, if at all, work and preserve our privacy. The idea is very simple. The idea is think about privacy at the beginning of the project rather than the end. It's easier, it's cheaper, and doing so later on at the end of the project simply might be impossible or just too expensive to do. So the idea of privacy by design is a policy notion addressed at engineers and asking the engineers to embed privacy into the design, into the specifications of the technologies, as well as business practices, physical infrastructures, etc. It has been advocated by Dr. Anne Kevokian, the former Ontario, Canada Information Commissioner. It has been adopted, it took some time, but it has been adopted by major data protection agencies, especially in the 2010 Jerusalem, so-called Jerusalem Resolution. That was the major conference of the data protection commissioners that took place in Jerusalem a few years ago. Thank you. The Jerusalem Resolution was that privacy by design should be recognized as an essential component of fundamental privacy protection. The idea, once again, was adopted by the FTC in the United States as a recommendation addressed to companies rather than to government, and in the recent European GDPR, which is the General Data Protection Regulation, data protection was adopted as a legal principle. What exactly that means is yet to be seen. So the idea sounds very intuitive and great and simple, but what exactly is privacy? So David suggested that we define security as cybersecurity. We can do the same with privacy, and we will get many very different definitions of and explanations of what exactly privacy is. When we talk to businesses and say, hey, you have to care about privacy, they will say, well, we would like to collect as much data as we can, and we don't quite know what we will be using it for, hence we cannot inform and ask the data subject's consent because we don't yet know what exactly we will be doing that. We want first to collect and then figure out what exactly to do with it. So privacy, well, we don't like privacy that much. Technologically, we speak to engineers. Many of you in the room are engineers, developers, designers, and we ask them about privacy, and they say, well, and then they start speaking about data security. Data security is an important part of privacy, but only one component of privacy. In a previous study with some of my colleagues, we interviewed engineers and we read their books, kind of 600-page books. Usually on page 600 it says there's a section about privacy, and it says something like, privacy is very important, ask your lawyer. When we read the book and the subtext between the lines, we see that the attitude towards privacy is, well, either non-existent or quite hostile, or reduced to issues of data security, but without many other legal measures or principles that we lawyers often discuss. So perhaps privacy by design can work despite all of these challenges. One area in which we are looking at is the governmental sector rather than the private sector. Perhaps there, privacy by design can actually do the work. So together with my colleague, Professor Avner Levin of Ryerson University in Canada, we are looking into several case studies. So Avner is looking into these case studies, the Lottery and Gaming Corporation Self-Exclusion Program. Here's the problem. People say, well, I'm addicted to gambling, help me. How can we help you? Well, when I would like to enter a gambling place, a physical place, don't let me in. Okay, so the solution was biometrics, biometric identification, and privacy people are very nervous about biometrics, but nevertheless, this was initiated by the Data Protection Commissioner in Ontario, Canada, and the discussion was with the gambling venues and the gamblers how to help themselves by preventing them from entering the place, even when they say, I want to go inside. So that is one case study, and the other is transit, transportation issues, how to better handle that with video recordings which include human beings. So that's Avner's case studies. I'm looking into 2 Israeli case studies which might come up in other places as well. Every now and then we have elections, general elections. It should be every 4 years, sometimes it's every 2 years, etc. The parties, the political parties, and we have many of them, not just 2 or 3, on a regular basis, every time there are general elections, they receive a copy of the population registration which the government handles. And the idea is, well, this will help you, prepare for the elections, approach voters, etc. At some point, the parties said, well, elections here are not only every 4 years, they're every 3 years or 2 years or sometimes even less. And we have our internal political procedures. We have primaries. Every now and then we have to get rid of our chairperson. In the Labour Party, every 6 months or so. Other parties, every year or 2 years, they at least try to do that. So we need the data on an ongoing basis. The Ministry of Interior, which manages the registration, the population registration, said, well, we understand. We are here to provide you with service, and yes, there's no problem in handling the data. Well, wait a second, there are some privacy issues here. And they've been struggling what exactly to do with it. One suggestion was, well, maybe the parties will hand their databases to the government will update the data and return it. Updating the data is important. Some people change their address and, their districts, Jerusalem district, Tel Aviv district, etc. Some people change their names because they get married or divorced or for whatever other reasons, and some people die and there's no longer a need to approach them. That's the need. And when the suggestion came up, okay, maybe the parties will hand their data to the government will do that. It took the Data Protection Commission to say, well, there's a problem there, not a privacy issue, but a democratic problem. It's none of the government's business to know who's a member of which party. If a person on his or her own wishes to say, I'm a member of this party, that's fine, but it's none of the government's business to know anything about that. How am I doing with my own time? I have to self-regulate. Okay. The solution then came up, and it came up once again from within the Data Protection Commissioner, and the solution was, well, a no-brainer for technologies, people from technology. Let's have a black box. And it took a while, and now we have regulations, which are a law, binding law, which regulate the transfer of data. And the idea is quite simple. A political party which is interested in updating its own registration will call the government, the relevant people, officials, and say, hey, we want to update it. We would like to update our registration because we have primaries or whatever. And they will set a date. They will buy a new computer, brand new computer. A person from the government will come with a disk on key, I guess, with a reduced population registration, not all data fields about each person, but only those that are relevant. The party will come with its registration. They will put it in the new computer, mix the data, and each will get back what they need, nothing more, nothing less. And then they will probably destroy the computer or something like that. Simple. It's a no-brainer, but it took so many years to come with the solution. This is a privacy by design solution. It answers the need, but only with the minimal data needed. It does not leave the government with a copy of the party's registration, and the party does not receive more than it needs. A second case study is about publication of names in judicial opinions. Many people today, before we hire someone or fire someone, I ask my students, and before they go on a date, they Google the person with whom they are about to have the date, or if it's in a business context, etc. People Google each other. In the Israeli case at least, whenever you Google someone, usually within the first page, which is all that matters, you will find a search result which would say Yossi Cohen, that's the John Smith of Israel. Yossi Cohen appears in Cases and Laws. That's a reference to a commercial database which offers access to its data only to some limit for free, and then they charge. And here's what happens. The employer Googles the person and sees that he was involved in some case. End of hiring process. If he lost, oh, so he's a liar, cheater, whatever. If he won, he's a troublemaker. I don't want him. When you go on a date, you Google the person, you will see he or she were involved in some legal action. You say, okay, I don't want to date this person, and you don't even bother reading. Most people are not lawyers and will not understand what exactly is going on in the case anyway. On the other hand, obviously, access to judicial opinions is wonderful. It's a core principle of our judiciary. So we have to figure out a way of how to do that. So we want to have privacy on the one hand, and we would like to promote the publicity of cases. How do we do that? That's our beautiful library here at the law school. These are the case laws, the blue ones of the Israeli Supreme Court. Lots of names. This is how people used to access names in old times, meaning, 10 years ago. They would go to the books and read. Who would go to the books? Lawyers, judges, law professors, sometimes our students as well, sometimes, okay? Today, obviously, it's done through the computer. There's a change in the availability of such data. Here's a breakdown of the judicial process as far as we are concerned. Someone initiates a legal action. Someone then manages it. That's the judicial administration. Then at some point the judge writes a decision, writes the opinion. It is then distributed initially by the judicial administration, and then it is made available by databases such as Westlaw, or in the Israeli case Nevo, Takdin, etc., and of course by search engines. And then at some point someone might ask that the decision be deleted, the right to be forgotten, which is much discussed. What can we do about it if we think there's a problem? We would not like to ban publicity of everything. We would not like to have full publication of everything because of the privacy implications. So here, according to the breakdown of the flow of the information, some solutions. None of them is perfect. It's not about solving the problem, it's about managing the risks, as David suggested in the cyber context. Well, maybe we can allow people to initiate proceedings anonymously. We have that in family law. We have that in cases of adoption, for example. In Israeli law, we now have it also for torts regarding body harm. Okay, so if you were involved, God forbid, in a car accident and you want to sue someone, you will now be able to do so anonymously. And then, the judges, for example, when they write the decisions, they can say plaintiff and defendant. They don't have to say John Smith or Yossi Cohen or whoever it is. They can use less information in the opinion. They must use as much as they need to solve the case and make their decision. Maybe the judicial administration, upon distributing the content to the commercial entities, can say, well, we provide you with this material in order for you to distribute it for free, but we require that you prohibit Google from indexing the content. The judicial administration here did so, but then one of the companies petitioned the Supreme Court, which said, well, that's a bit of a problem because of what we call freedom of occupation, which doesn't sound well in the Israeli context. That's my time over. And the Supreme Court invalidated its, different officers' decision about what to do about it. So none of the solutions is perfect, but each on their own and their accumulation might somehow achieve a better balance. So we are looking into this with the idea of figuring out what can help privacy by design, maybe, work better within the governmental, public sector context. Well, governments and its branches are subject to administrative law, which regulates the process of the decision making. These bodies are subject to constitutional law, which requires them to take account and care about privacy. Money, budget, plays different in the government compared to a private entity. The government, if it has expertise about privacy, hence the importance of a central data protection or privacy protection board, advisory agency. Different countries call it in different names. It's important that they be independent as much as they can. And of course, when the solution is easy, well, it's easier to do so, such as in the black box political context that we saw earlier. Okay, that's it for my talk, and I believe we do have some 5 minutes or so. Did we get a microphone? No? No. Okay. So questions to Susan, David, or myself, you are more than welcome, and we'll find some way to answer that. Anybody? We discussed earlier, Susan discussed the difficulty of distinguishing content from data about the communications. We then heard about the American legal context of hacking or just breaking in or just getting information from the iPhones in the law enforcement context, and we heard about the switch or the shift that we should be doing towards risk management of security, cybersecurity issues. Yes, please. Please do. About in the Israeli context of the yeah. 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 Right. So the question was about whether political parties use or abuse the data, I guess. Okay. Yeah. Over here, in the Israeli context, well, we have to match the previous discussion with the regulation of the political system. In the Israeli context, well, the entire country is one district. For the parties, some of them, the larger parties, the Likud, the Labour, and maybe some others, they have their own districts. But then there's a separation between the party and the government. The government does not interfere how each party manages its own internal affairs, but for extreme situations where there's, some illegal stuff going on, etc. But a party can decide that the entire country is one district, or it can divide the country into various districts. It's the party's discretion, and the government does not interfere with that. So that is irrelevant in the Israeli case. In the American case, well, if someone is a registered member of this or that party, it's public knowledge as far as I know to begin with. And then the government, does use that, or let's say political powers use that to redefine the borders of the voting districts. So it happens to be that, a certain group is a minority in its district, and hence we will transfer it to another, etc. That's the gerrymandering that you mentioned. Yes, thank you. Okay, so I guess we will turn over to the next panel, which is headed by Yaniv, and we'll discuss encryption and decryption issues. No break, we are continuing for another hour, right? Thereafter, there will be a lunch break. Please join me in thanking my colleagues for their talks. Thank you.